Court, Counsel. Bruce Reich, here on behalf of the appellant Palmetto Surety Corporation, which is the surety who oversaw surety agency big deal bail bonds on a defendant who missed court, defendant Bu Ramey, back on July the 8th, 2013. We're here on an appeal from the Circuit Court's denial of the surety's application and then amended application for remission of forfeiture under primarily statute 903.28. Statutorily, there are two general areas for purposes of our appeal that remissions are allowed. In fact, the statute says shall. It's mandatory, either when there is an arrest or surrender, whether it's by the court or law enforcement or by the surety. But there's another method by which a remission would be mandatory to be considered by the court, and that is when there are substantial efforts that are being made by the surety in order to, in effect, an arrest or surrender. And
can I ask you, there was an affidavit of efforts, and my understanding is that affidavit was not introduced in evidence.
Well, here's what happened. While it was filed, shown to counsel, as I recall before the hearing, and we discussed it, my understanding is that there was a stipulation for the facts, with the exception of that portion of the affidavit which discussed any testimony by an indemnitor, Philip Cherry. In other words, the surety agents, Ms. Khaleesi and Mr. Carroll, that did what was done even before the forfeiture was noticed to the surety, were in court. And so my understanding that it was no dispute as to the facts, and I looked over, and first time that there was any question as to whether or not the facts were, if anything, not agreed to, was from Appellee's brief, which was kind of surprising because in this case on page 65 of the record, the court even started out by saying pretty much these facts are agreed to. Let's just get to the point and let me hear from counsel for Pasco County. Page 70, line 24, page 71, line 20, where I cited essentially stating my understanding that these facts are not in dispute, that these facts are agreed to, and I even noted with the exception of that which was discussed before the hearing, as to only what Mr. Cherry had said, who guaranteed the bond, not coming in for the truth of the matter. That's why I specifically stated that caveat. So that is true. There may have not been the magic words, Your Honor. Will Your Honor therefore accept all the facts in my motion, what's being argued, and that's what's in the affidavit as part of the record. My understanding was that it was part of the record, and is bolstered by the fact that on page 72, line 6, when the reply opportunity came for Mr. Roberson, who was there, he basically stated nothing to the effect of, no, we didn't agree to the facts, let's call the witnesses. It was more to the effect of, well, going out to looking for the defendant does not satisfy the issue. The whole argument by clerk's counsel was that because there's a breach of the bond under the statute, that does violate statute 903-281 and therefore prohibits any remission. So the court is correct. I did not recite the magic word saying, Your Honor, this affidavit is acceptable. Actually, the affidavit is required as part of the motion in order to move for remission of the bond, and that assists the court from the outset. But I feel that I was totally blindsided if there was a position that was being raised that somehow all the facts in this case were not stipulated to. There was never a dispute as to the facts. In fact, from the court's order in the case, the court specifically did not, obviously felt that as a matter of law, the court could only rely on the first provision of 903-282, and that is only an arrest or surrender was required based upon this court's decision in the Sunshine case, which is cited, and based on the 5th BCA's decision in All-Star. And the court didn't address it and ruled that as a matter of law, the surety was not entitled to relief. So we're here to request relief for the court to reverse, if necessary, remand, and direct a remission based upon the other provisions of the statute which allow remission or call for remission when there are substantial efforts. If there's
for us to remand, at least to direct the trial court to consider whether the efforts were substantial to justify partial remission, and if so, in what amount. That's what you want.
That's correct. If it's not clear whether it's substantial as a matter of, I guess, de novo review by this court, if there was a question as to what's substantial, then I would ask that some scenario, it's an alternative scenario, ask the court to consider making a ruling on that.
We're not in the business of making an original determination.
Exactly.
Whether the efforts were substantial.
Exactly.
So you want us to send it back and tell the trial court trial court, in the exercise of your discretion, determine if these efforts were sufficiently substantial to justify partial remission, and if so, tell us. That's
Correct.
what you want.
That's essentially it, and I think that's what also was alluded to, not in the same way, by this court in the Sunshine case. In that case, they stated, I believe, it was never submitted, never argued, never alleged. The efforts that were made by the surety to go on the second prong, and that was not considered. And I think even based upon this court's prior ruling, that would be allowed. And I think the court felt bound in the lower court not to follow that as a matter of law. Again, I don't think there was any factual basis whatsoever, and I think the record is clear as to what my understanding was where we're at factual-wise. And probably, if I forgot, I would ask for 5 minutes at the end. I don't know if I'm almost done. So I think that the All-Star case, I think Sunshine for this court supports our conclusion that had it been raised, the efforts made by the surety in that case, I think that we would prevail based upon the Sunshine decision. But what's interesting in this case, and what we've alleged, and what is really the question is, the surety didn't wait for any notice to be mailed. The indemnitors who were in touch with the surety, they were supervising this case during the course of the case, at least the facts that we presented. And if those facts are in fact true, then they were on top of this even before the notice of forfeiture was sent. Notice of forfeiture.
That argument is for the trial court, is it not, Mr.
Correct.
Reich?
Correct.
In other words, if we were to send this back to the trial court and the trial court were to make sufficient findings, saying, I've considered all of Mr. Reich's arguments, I find the efforts insufficiently substantial to justify remission, that would be bulletproof.
Correct. I believe so. If the court were to make those findings, I'm obviously hoping that there will be a sense to stipulate based upon what the surety did. The surety agents was there, but I don't want to reiterate that. I think if it would be hashed out as a factual issue, I don't think there's any question that would apply, and I think we did not have the opportunity to address really the facts on the case, or for the court to consider those facts as being substantial or not. There was something else that was raised by Mr. Roberson, clerk's counsel, that was really not directly raised, and that is whether the prosecution was thwarted. And yet the law does not assume thwarting of the prosecution. In some cases where a year goes by, a year and several months go by, such as in the All-Star decision, and in other cases, and the case cannot be proved because the state has lost evidence or witnesses, then there could be an argument of thwarting. It was never brought up by appellee at all in the lower level as to whether there was thwarting. The prosecution was present. This is essentially a petty theft charge as a felony petty theft case. Where the defendant missed on July 8th, was dead on July 15th. I think that there clearly could not have been a thwarting. Again, if that has to be raised, it wasn't raised. If it needs to be raised, I would welcome a court's determination that there was no thwarting as a result of the delay. The only thing that would have thwarted the case, of course, is the defendant's death, just like, for instance, in the county bonding case in the 3rd DCA, where they said, well, certainly there could be a thwarting by the defendant's arrest by leaving the country, but the question is if the presence...
There in county bonding, thwarting was the state itself
exactly
being unwilling to go through the elaborate procedure to bring about the extradition from a foreign country of the defendant, and the 3rd District naturally concluded that that was in effect an abandonment by the state and the county of any entitlement to any relief. That's different from thwarting.
Exactly, and they used the word prejudice. They said the case was not prejudiced factually because they had a confession in the case. So they looked at an analysis. They said the fact that the defendant wasn't back is not what the thwarting was under the 90328, or would be the issue. That would not be the issue. In this case, the issue is factually, could the state have proven the case absent the defendant's death 7 days later? So I think when we look at an analysis of thwarting, and the court, if the court would have an opportunity to review that and raised by Pasco County, I think the surety would prevail on the thwarting argument. I believe that the clerk's counsel mistakenly also stated that a rest would be absolutely required. In their brief, they stated that it would have to be required in order to justify remission, citing both to the county bonding state and continental heritage of the 5th DCA. I think it was an inadvertent misquote, because in that case, they cited to the fact that there was an arrest in county bonding, but in Continental Heritage, there wasn't an arrest. The surety had located where the defendant was in Jamaica. There was no arrest. It was the state's action that thwarted that arrest, but there was no arrest. So that means the court, I think, would have the authority at least to entertain this on the alternative, the ground that we raised. Rather than belaboring it, I'll ask to reserve the rest of my time.
Okay,
Thank you.
May it please the court.
Counsel. Clint Robertson, representing the Pasco County Clerk of Court. I'd like to start my argument by reminding the court here today that the standard of review here today is whether or not the trial court abused its discretion in denying a remission of the bond distructure. And with that in mind, I've laid out 3 points to my argument as to why the trial court did not abuse their discretion. The first is that there was no apprehension or surrender in this case. If you look at Florida statute...
That's not contested. Mr. Reich is not suggesting the contrary. But 903.28 says either or. Arrest or surrender or substantial effort.
And my reading of the statute, each of the subsections do start out, if the defendant surrenders or is apprehended. Then it goes on to say the distinction between...
later in each subsection says, or there are substantial efforts to bring about the arrest or surrender.
Yes, and in the All-Star case as well as the Sunshine case, the cases that the trial court cited, they do essentially say that apprehension or surrender is part of the requirement. The only distinction there is that in the Surety Continental as well as the county bonding case that counsel relies on, in those cases they've been distinguished because in those cases the state, those were dealing with extradition.
Those cases are inapplicable, aren't they? They're inapplicable.
I agree, yes, they're inapplicable because those are cases where the state is the reason.
It's a simple principle of contract law that one party to the contract cannot benefit from its efforts to disentitle the other party to perform. That's what county and continental surety stand for, correct?
That's correct.
And for that reason, they have no applicability here.
That's right.
But surely it's not your position before this court that there must be arrest or surrender.
Well,
that's not your position, is it?
That is part of. Certainly, I see that some cases do distinguish that. However,
the statute clearly says arrest or surrender, or substantial efforts towards arrest or surrender.
Yes.
The statute couldn't be clearer on that point, could it?
And in regards to the substantial efforts, it's my position that there certainly were no substantial efforts in this case. Even assuming
that's an argument directed to the trial court, correct?
Yes.
Right. Yes.
But
look at the last. Do you have the trial court's order in front of you?
I do.
All right. Look at the last paragraph of the trial court's order. Doesn't the trial court state pretty much unequivocally that it's proceeding on the, not pretty much, unequivocally, that it's proceeding on the notion that there must be arrest or surrender? It never considers substantial efforts as an alternative avenue to partial remission.
I agree with that. I agree with that. My position is, in looking at 903, and if I may just for a moment, if the defendant surrenders or is apprehended within 90 days, that's how it starts, after forfeiture, the court, on motion at a hearing upon notice, having been given to the clerk of the circuit court and the state attorney as required in subsection H, shall remit remission up to, but not more than 100% of a forfeiture, if the surety apprehended and surrendered the defendant, or the apprehension or surrender of the defendant was substantially procured or caused by the surety. But what I'm saying is that the beginning of the statute, it starts off, the prerequisite of the statute, the or part that you're referring to is after the initial part. The defendant has to be apprehended or surrendered. And to me that makes sense, because if that wasn't a requirement, then surety could simply allow a defendant to abscond, make a few phone calls, find out where they think they are, and then show up to the trial court and say, I demand a remission. And that leaves them with no incentive to actually apprehend the defendant.
There's no suggestion those are the facts here, is there?
No, they're not. They're not.
In fact, if a surety were to willfully let the principal to the suretyship flee, that would have far-reaching legal consequences, wouldn't it?
Absolutely, yes. But
that didn't happen here.
That didn't happen here. There's no suggestion that happened here. But I certainly do believe that apprehension or surrender is a part of that. I think if you look at 903-28-7, it talks about how there can be no remissions granted other than what's allowed in this statute. And then the All-Star case clearly says, to date, it appears that Florida courts have recognized only one exception, and that is where the state prevents the surety from producing the defendant. I don't believe that the appellant has raised that exception at all. And I don't believe clearly not. And I don't believe that any of the exceptions have been applied. Our understanding and our ruling, and it was as well with the trial court, their ruling in looking at these cases, the 4 cases, he cited Surety, Continental, as well as county bonding. We cited Sunshine and All-Star. And looking at those, the court found that that surrender or apprehension is required. And in looking at the wording of the statute, I believe that's so as well. Again, I understand that it's the court's position at this point that maybe for the trial court to decide whether or not there was a substantial attempt to procure the defendant.
Apparently you persuaded the trial court that there must be surrender or apprehension, that mere substantial efforts can never support even a partial remission. You were triumphantly successful with that argument before the trial court, were you not?
Yes.
All right, and you're defending that position here today?
I am, yes.
I understand, okay.
And the reason that I do bring up substantial attempts as well as the thwarting is because those issues were also raised in appellant's brief. So I believe I have to address those. And in regards to that, even assuming that the affidavit was entered, I don't believe making a few phone calls, telling the defendant when the court date was, and then finding out when the indemnitor, and then finding out from the indemnitor that the defendant had left, I don't believe that those are substantial efforts in any way. And I think the prosecution was certainly thwarted. Again, the words of All-Star, it definitely says that the absence of a defendant when they have missed a court date and then are not procured before their death, that's a thwarting of the prosecution. I think the All-Star case is clear on that, and it's the most recent as well.
Other than All-Star, can you cite any case for the proposition that death does not thwart the prosecution? Absence is what thwarted it. Because it seems on these facts that it was the death of the defendant that thwarted the prosecution.
Well, yes, but that is true. That it's certainly the death ultimately. But All-Star clearly says it was the surety's failure to not have the defendant at the original court date, coupled with the failure to procure the defendant before their death, that led to the thwarting of the prosecution. All-Star talks about both of those. Now, ultimately, in the end, yes, it was the death.
Other than by virtue of the defendant, the criminal defendant's, the principal's death, was the state thwarted? In other words, was there any lost witnesses, lost evidence, unavailability to proceed in any way?
No, that's not a part of the record, no.
Okay.
But I'm not even sure, though, it's the failure to appear or death that under the statute is what the thwarting that they're referring to. The statute refers to whether the delay has thwarted the prosecution, and it suggests to me that a delay to thwart a prosecution, the delay would have to be such that witnesses aren't available anymore, or memories have faded, or maybe witnesses have died. But I don't know that not appearing and dying are the kind of thwarting that the statute
Well, certainly
contemplates.
allowing the defendant to fail to appear, and then that defendant attempts to flee, and that delay of the defendant attempting to flee and then passing away caused a thwarting of the prosecution. The
prosecution couldn't occur before he died.
That's true. Well, there may have been, who knows, maybe the date he could have entered a plea at the date, and that may have resolved the prosecution if he had been at that court date and entered a plea,
But the question is whether the delay has thwarted the prosecution, and I think you really need to more not what would have happened if he had shown up, what would have happened if he had not died. The question is there some aspect of the delay that has thwarted the prosecution, and I'm not sure a week is going to do it here.
And I do realize that there's a difference in time between the cases that the trial court relied on and the instance here being a week. However, still, I think if you start distinguishing that, there becomes a problem. I think it's a slippery slope. Then
Well,
how long is too long?
I'm just reading what the statute says. I didn't make the statute up, you know, and so it's the delay that has to thwart the prosecution to prevent the.
Yes, and I think the delay of the defendant missing the court date and not being able to be brought back and be prosecuted, that delay, that aspect of the delay thwarted the prosecution. Sunshine says the risk of a defendant not appearing is borne by the surety, and the surety, in order to protect its own interests, must take precautionary actions to prevent this type of situation. I think that the facts of Sunshine, as well as All-Star, are right on point with the facts that we have here. The only difference is the amount of time. And I don't believe that the legislature has drawn out a certain amount of time that's appropriate or not. And they are much more, the two cases, Sunshine and All-Star, are much more on point with the facts than are Surety Continental and County Bonding. Those cases certainly just deal with the extradition. Those are cases where, in the Allegheny case, it says the reason that those cases carved out an exception to the statute are that those were cases where the surety was ready, willing, and able to procure the defendant. But it was the state that prevented that. The state actively prevented that. And those are far from the facts here. The surety here was not ready, willing, and able to procure the defendant. And that goes back to my
With respect to Judge Northcutt's question, wouldn't we have to have before us a trial court order that made findings that a key witness died or a key witness was drafted and sent to Iraq, or the evidence, the drugs were destroyed, something like that? Isn't that the kind, aren't those, these are obviously just examples, but aren't those the kinds of things that we'd have to have, the kinds of findings we'd need the trial court to make in order to affirm a conclusion that the delay thwarted the prosecution?
I don't believe so. I don't believe so. And the trial,
explain that to us.
The reason is because, again, the language from the courts are that the delay, again, the delay of missing that first court date coupled with not being able to prosecute the defendant before their death, that is a thwarting of the prosecution. That delay of missing that court date and being gone for that time kept the state from being able to go forward with the case. I don't think you need specific findings of that.
If the defendant had shown up alive the next week, would the state have been prepared to go forward?
That's not necessarily part of the record. But there's no contention that they would or would not have been. That's
so what for his death, the state would have been, they had their witnesses ready, they had a prosecutor who was prepped and ready to go, the exhibits had been marked, ready to rock and roll.
I can't attest to that, certainly not. But I do believe that that if we ask each court to make those findings each time, I believe that it's slippery slope. I don't believe that's part of the legislature's of the law. I believe it's a delay whether or not forwarded.
I don't know. I mean, I will tell you. I mean, this was a trial date that was set, but I mean, I don't know how they're doing it up in. This was in Pasco.
Yes.
In Hillsborough, they constantly set those trial dates, and if date comes and everybody knows they're not going to trial today, they just move it down the line until they, either don't have a waiver of speedy trial or come up against that. Does our record reflect what was going to happen on that day? Were the witnesses there? Did the state have its witnesses, or was this going to be a...
That is not a part of the record. I believe it was just a court date.
So what you're arguing, though, is the statute says if it's scheduled on paper for trial. And again, I don't know what the practice is in Pasco. Maybe you do. Maybe that is how it happens there. But if the docket says it's a trial date and he's not tried that day because he didn't show up, that thwarted the prosecution regardless of whether, and there's no more showing than that, even though, as a practical matter, there may have been no way that trial was going to happen that day and everybody knew it. He didn't show up like he was supposed to. Can't that be the case?
That could have been the case, yes. The prosecution could not have been ready.
Thwarting the prosecution, there would have to be more than that, would it not? Just because he didn't show up for a day he was required to be there, basically. Again,
it's our position that them not showing up, that is thwarting the prosecution, and that puts a delay in the case.
So the statute doesn't even really need to say thwarting the prosecution. All it has to do is say there was a delay. There was a delay. There was a failure to appear. I mean, the thwarting the prosecution becomes fairly extraneous if that's how the statute is interpreted.
Well, in a case where the defendant was brought back and there was no delay, I think then maybe you could make a distinction. But in this case, the delay caused the death, which caused the prosecution's inability to do that, to prosecute the defendant.
Unless there was not going to be a trial that day, that he didn't show up.
Potentially, again.
So now, if he dies, regardless of if he dies and he doesn't show up because he dies, there's no possibility of a remission of that forfeiture.
Yeah, I'm sorry.
Because you can't be prosecuted now. That's like the permanent delay.
That's true. Well, it's our position that yes, that is the case. And I think, though, before we even get to the thwarting, again, the apprehension or surrender aspects of All-Star and Sunshine, again, these are cases where I believe the appellant has argued that in these cases, they never argued that there were any substantial attempts. So All-Star and Sunshine don't apply because they didn't argue substantial attempts as he did. However, if you, in looking at the All-Star dissent, they clearly say that there were very substantial attempts to procure the defendant. They actually go into, they say there's no contention by either side that they did not do everything they could have to procure this defendant, but they still denied the remission. And it's my position, and that's because the apprehension or surrender is required. And again, even if not, there was no substantial attempts. There were no substantial attempts under the facts, under the record, and there wasn't a thwarting of the prosecution. I'd like to reserve the rest of my time for any other questions of the panel, but for the reasons I've stated, there was no abuse of discretion in this matter.
Okay. Thank you, Mr. Rice.
Thank you.
I guess I'll put one little point I wanted to raise about the thwarting issue, because it doesn't come up a lot. But
Well, you know, the state's argument is you don't even get to the thwarting issue. Because
right. And I think in the Allied bonding case, which was not cited, but it's 358 Southern 2nd 246, that was the 1978 case, 4th DCA, it stated something to the effect of course, any disappearance of a defendant delays and somewhat thwarts prosecution, but we cannot say it's always does, or else the statute would be rendered meaningless. So I think really that's
Mr. Reich, what about counsel's reading of 903.28? He says he's very forthright in his position. He says there must be apprehension or surrender, and he persuaded the trial judge that that's the case.
If that's the case, then the 5th DCA in the Continental Heritage case, that was a case where there was no apprehension of, or surrender in the case. If the argument is contrary to the plain reading of the statute, and I believe there's a Dolly Boulding decision of this court, again not cited, the legislature has put this language in there, and we cannot second guess what is clear language. If it was not, it's not intended, and if we don't like the fact of what the legislature meant by it, or are questioning it, and there's no question about that, then really that is up to the legislature to amend it and take it out or clarify it. I don't think there's anything unusual, unfair in the applicability of that statute that way, especially to this type of case, where I think when the standard of the law is that forfeitures are not favored at law, that's the general proposition, and we're governed by statute, and a result that goes against the surety in this case, where they're looking for the guy even before they get notice of forfeiture, is pretty harmful in an equitable sense. But we don't have to proceed under equity. We can proceed under statute. The statute in this case, under the way it's written disjunctively and giving those remedies, really allows for this type of equity to be remedied. And I totally disagree about a slippery slope argument. It's basically what our judges are here for, to determine what is real and what is nonsense. I firmly welcome an analysis by court to determine whether or not it's bona fides as to what the surety is alleging, or whether it's just nonsense or self-serving. And in this case, there's no question or issue as far as credibility as to what really went down, and we're still talking literally about a 7-day period of a mess for this defendant, who by all accounts died in Ocala within the state, and from the death certificate was handled by a funeral service in Ocala. And he didn't run, and by all accounts would have been arrested.
Were the police called to the scene of his death?
Don't know.
I mean, if they were, which is often happens, right? Would that have been an apprehension?
Well, I get questions by bondsmen where the defendant's dead, and we have the very, very difficult state of the law, that it is statutory. Thank God we have that disjunctive provision in there. But if somebody just dies, and we say, well, can we bring the body to court? Because that's what it traditionally says.
It doesn't say they have to come to court, they have to surrender or be apprehended.
Yes, and they ask, can I bring the body with us and exhume the body, sarcastically asking? I said, I wish you could, but the law is very funny in these ways. It allows a remedy, and I think the statute does allow this remedy. And again, I think the remedy for the clerk's counsel for Pasco County is if they disagree with what was put in there, and that language is specific in there, then I think they need to go to the legislature and say, no, we want it to be absolutely clear that that should not be even a statutory remedy that's allowed by the court. So that's,
Okay.
thank you.
Thank you both very much. And with that, the court is adjourned for the day.